The September 22nd, 2021 meeting of the Board of Zoning Appeals is now in session. Good evening and welcome to this meeting of the Arlington Board of Zoning Appeals, which is also known as the BZA. I am Inta Malice, Chair of the Board. The board is made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Vice Chair Paul Melnick and members Judy Freshman, Portia Clark, and Lindsay Arthurs. Also present is the professional staff, including Cliff Hogan, Assistant to the Zoning Administrator, Blake Bowen, Board of Zoning Appeals Coordinator, Stephen Rissy, the Zoning Prim Supervisor and current BZA Secretary, Arlova Vaughn, Zoning Administrator, Kevin Black, Assistant County Attorney, and Patty Petrosini, Assistant to the BZA. Thank you for joining us this evening. Before we start, we will show a brief video that explains how the BZA makes its decisions and how we will conduct the hearing tonight. Mr. Bowen, are you having a technical issue?
Madam Chair, I'm able to hear the video on my end. Are you not able to hear it on your end?
No.
Okay. Just a moment. Let me start that over.
If it's a problem, I can do it live.
I'll try restarting it.
Good evening and welcome to this meeting of the Board of Zoning Appeals, which is also known as the BZA. For the safety of our board members, county staff, applicants, and participating community members, we are meeting in a virtual format this evening, and all participants are joining the meeting remotely. We are legally authorized to hold this virtual meeting based on the governor's executive orders, legislation adopted by the Virginia General Assembly, and the Arlington County Board's Continuity of Operations Ordinance adopted in March of 2020. Before we call our first case, I will share with you some general information about the Board of Zoning Appeals, and then some ground rules on how we will conduct our virtual meeting. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the county board. This board does have the authority to do 3 things. 1, we can approve use permits that allow modifications of placement requirements of structures on 1- and 2-family lots where there is no option in the zoning ordinance to allow for such modifications. 2, we can grant variances from the specific requirements of the zoning ordinance. And 3, we can decide appeals of decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the board find that the proposal meets certain conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. To do this, the BZA shall consider 1, whether the modification will promote compatibility of development with the surrounding neighborhood because the structure's overall footprint, size, and placement are similar to the structures on properties surrounding the lot in question. And 2, whether the modification will help preserve natural landform, historical features, and/or significant trees and foliage. When granting variances, the burden of proof is on the applicant to prove by preponderance of the evidence that the improvements meet the following criteria: whether the strict application of the ordinance would unreasonably restrict the utilization of the property, or that granting the variance would alleviate a hardship due to a physical condition relating to the property, or the improvements thereon at the time of the effective date of the ordinance. Whether the granting of the variance would alleviate a hardship by granting a reasonable modification to a property or improvement thereon requested by or on behalf of a person with a disability, and whether the property for which the variance is being requested was acquired in good faith and any hardship was not created by the applicant. The board also considers whether the variance granted will not be of substantial detriment to adjacent property and nearby properties in the proximity of the geographic area, that the condition or situation of the property concerned is not so general or recurring a nature as to make reasonably practical the adoption of amendment to the ordinance, that granting the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, and that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning or subdivision ordinance. When deciding appeals of the zoning administrator, the board must use its judgment to determine if the administrator was correct. Now for tonight's meeting procedures. The staff reports for each case on tonight's agenda can be found on the BZA website. Staff has placed a link to the agenda in the chat section of the session. If you have not seen the report for your case, you may wish to review it before your item is called. Staff has also placed a link in the chat for supplemental material received after the staff reports were prepared. The order of our meeting is as follows. First, cases will be called and staff will give a brief report and provide their recommendations. Following that, board members will ask any questions that staff may have. Next, applicants or their representatives will be given an opportunity
No audio.
We have deemed the following time limits for applicants and speakers to be sufficient. 20 minutes for applicants of appeal, 5 minutes for applicants of use permits and variances, 3 minutes for speakers representing organizations, and 2 minutes for those speaking as individuals. After the board has gathered all the information we need and has discussed the case, we will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. Now here are some specific instructions about how this evening's virtual meeting will run. Tonight's meeting is available to stream from the county website via a Microsoft Teams link. There's also a dial-in phone option for those who wish to use it. If board members, presenters, or speakers lose internet connectivity during today's meeting, please reconnect with us by phone. Please keep your phones and devices muted until you are called upon. Turn off any sound to any other devices around you to minimize interference. For those joining via Teams, please turn off your video feed. Only board members will leave their cameras on. When called upon to speak, please turn your camera on and unmute yourself by clicking the microphone icon that is located on the meeting command bar. The moderator does not have the ability to unmute you. If you are dialing in by phone, press star 2. Meeting chat is active for presenters or board members who need technical assistance only. The meeting chat should not be used for discussion, public comment, questions about agenda items, or requests for more information. All public comments must be shared verbally for the record during the assigned public testimony period. For board members, wish to be recognized to speak on an item, please seek recognition verbally as usual. You also have the option to use the raised hand function. In either case, once you have been recognized, you may unmute yourself. All voting tonight will take place via roll call. Applicants and public speakers, you will be called upon by county staff at an appointed time. Today's hearing was requested. We will accommodate any additional speakers only if time permits. Public comment will take place within the time frame stated earlier, the same as we would provide at an in-person meeting. During public comment, a speaking timer will be displayed on the screen by staff. If you are dialing in by phone and unable to see the screen, we'll provide an audible warning when 30 seconds are remaining. Be muted when your time has concluded. Lastly, this is a public forum. Today's meeting will be recorded and posted to the county website. All information associated with today's meeting, whether written or spoken, is subject to the Freedom of Information Act requirements. After your case of interest is heard, you are welcome to stay for the balance of the session or leave at your convenience. This concludes the introductory remarks.
Thank you, Mr. Bowen.
Mhm.
Before we start with our cases, I have a couple of housekeeping items I want to cover. One is we want to welcome Mr. Blake Bowen as our new BZA coordinator. We look forward to working with you. You're already seasoned, so I think it will be a very smooth transition, and we thank Mr. Rizzi for the service that he has given the board for a number of years.
Absolutely. Yeah.
So in that vein, I would like to make a motion that the BZA appoint Blake Bowen as the BZA secretary. Is there a second?
Second.
Second.
Seconded by Ms. Freshman. I will call the roll. Mr. Melnick?
Aye.
Ms. Freshman?
Aye.
Ms. Arthurs?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion to appoint Mr. Bowen as the BZA secretary passes 5-0. The second item is regarding our October calendar. I would like to add October 20th to our schedule in the event that we need a carryover, and therefore I move that we add October 20th to the BZA, October 20, 2021 to the BZA meeting calendar. Is there a second?
Second.
Second by Ms. Freshman. I will call the roll. Mr. Melnick?
Aye.
Ms. Freshman?
Aye.
Ms. Clark?
Aye.
Ms. Arthurs?
Aye.
Chair votes aye. Motion to add October 2021 to our meeting calendar passes. So to start with our cases, there are 5 cases that we are going to consider in a batch. These are cases where the application is complete. Staff has recommended approval and we're not aware of any controversy. I am going to call the numbers for these cases, and then I'm going to verify that there's no one here that wishes to speak on these items. If there's not, Mr. Bowen will then call each item and we will vote on these 5 cases as a group. The first case is V-11689-21-UP-1. The second case is V-11690-21-UP-1. The next case is V-11691-21-UP-1. The next one is V-11692 V-21-UP-1. And the fifth one is V-11694-21-UP-1. Is there anyone here that wishes to speak on these items? We've had no speaker
Just say that
slips
you
on
weren't
any of
called.
these.
We're supposed to be in them.
Is someone speaking?
We were not,
That was just the batch ones that they're approving because there was no objection.
oh, I see. Okay, never mind. Sorry.
Okay. So let's see. So I'm going to have Mr. Bowen formally call these cases. Thank you.
Okay, thank you, Madam Chair. Starting with the first case, V-11689-21-UP-1, a use permit request by Christopher Payne and Helen Methenpayne, the owners, to permit a right side setback of 5.9 feet to the wall instead of 8 feet to the wall as required, regarding a new 2-story rear addition and 1-story left side addition in the R6 zoning district on the premises known as 6046 21st Street North. Moving on to the second case, that is V-11690-21-UP-1, a use permit request by Anna Araby and Philip Holmes, the owners, to permit a rear setback of 17.5 feet to the deck instead of 21 feet to the deck as required, regarding a new rear deck to an existing one-family dwelling in the R8 zoning district on the premises known as 1516 North George Mason Drive. The third case is V-11691-21-UP-1, a use permit request by Nipa Mehta and Clark Edwards, the owners, to permit a rear setback of 16 feet to the screen porch, 15 feet to the eave, instead of 21 feet to the screen porch, 19.5 feet to the eave as required, and to permit a street setback of 20 feet to the front porch, 19 feet to the eave, instead of 21 feet to the front porch, 19.5 feet to the eave as required, regarding a new rear screen porch and front porch to an existing one-family dwelling in the R6 zoning district on the premises known as 23130 North Powhatan Street. The fourth case is V-11692-21-UP-1, a use permit request by Hector Ruiz and Janice Luca, the owners, to permit a street setback of 21.3 feet to the carport instead of 25 feet to the carport as required from the 5th Street South, regarding the replacement of a carport roof and post on an existing one-family dwelling in the R6 zoning district on the premises known as 2509 5th Street South. The fifth and final case is V-11694-21-UP-1, a use permit request by Mark Kearney on behalf of Ryan and Jennifer Miller, the owners, to permit a left side setback of 4.3 feet to 2 window wells instead of 5 feet as required, regarding 2 window wells to an existing one-family dwelling in the R6 zoning district on the premises known as 4619 23rd Road North.
Thank you. Thank you, Mr. Bowen. All of these applicants were notified before the meeting that their case would be heard in a batch at the beginning of the meeting, and looking at the participant list, they are all here. So we can move forward without any further discussion. Is there a motion to accept these, to approve these 5 cases?
So moved.
Is there a second?
Second.
Motion made by Mr. Melnick, seconded by Ms. Freshman to approve the 5 cases that Mr. Bowen just read. Is there any further discussion? I will call the roll. Mr. Melnick,
Aye.
Ms. Freshman,
Aye.
Ms. Clark,
Aye.
Ms. Arthurs.
Aye.
Chair votes aye. These 5 cases the use permits have been granted on a vote of 5-0. Thank you, applicants, for the complete applications. Mr. Bowen, will you call the next item? You're muted.
Sorry about that. Thank you, Madam Chair. I was just scrolling back to the proper case. First case is V-11687-21-VA-1. It's a variance request by Jonathan and Laura Bruskin, the owners, to permit a maximum main building footprint coverage of 35.1% instead of 28% as required, and a maximum lot coverage of 41.8% instead of 38% as required, regarding a near rear screened porch and rear deck to an existing one-family dwelling in the R8 zoning district on the premises known as 6201 30th Street North. Staff recommends that the board adopt the attached proposed resolution denying the variance. An alternative resolution and conditions have been provided should the BZA see fit to approve the application as advertised.
Thank you, Mr. Bowen. Any questions for staff? All right, is the, Mr. Bowen, I no longer see my colleagues. Are they with us?
I see Lindsay, Portia, Mel, Paul, and Judy all on the calls at this time.
All right. For some reason, I can't see them. Could you take the picture down? Maybe that will. All right, now I see it. Okay, now I see. Usually I can see them at the bottom, but I can't see them if they're wishing recognition. So no questions for staff? All right. Is the applicant, Jonathan and Laura Buskin, with us tonight?
Yes, hello.
Hi, good evening. Is there anything you'd like to tell us about your application?
Yes. So actually, I have a quick question. Are we addressing just the variance or both the variance and the use permit?
Only the variance was called, so we're gonna address them one at a time. Obviously, there's going to be some overlap, but you'll have another opportunity to speak to the use permit too.
Okay. I'll just make the comments that I was going to make for both, and then if I need to speak again later, I will. So I'm Jonathan. This is my wife, Laura. Hopefully you can see her in the camera. So we really appreciate the opportunity to speak to you all. First, I wanted to thank Stephen and Blake. They spent an incredible amount of time walking us through the process and were super patient with all the questions that we had. So just wanted to say thank you to the two of them. So, we just wanted to give a quick summary of, what we're requesting, which is relief on both the rear setbacks and the lot coverage, so that we can replace the deck that you see in the picture there and make the most of the use, the space for multi-use purposes. Without recapping our entire application, I did want to highlight two reasons why we've come to the board for this request. The first is, when we bought the house in 2013, we bought it from a guy who had owned the property and was sort of an amateur architect and architected the house on his own. Unfortunately, he built the house as it was built then beyond lot coverage, and we've been repairing mistakes, here and there since we bought the house in 2013, including replacing all the hardwood floors because they were done wrong. So the list is pretty long. This is just the latest in a series of things that we need to replace. Because he was able to build over lot coverage and make all kinds of shortcuts. So the deck that we're replacing that you see here is sort of starting to bow because the materials used were not correct. So in considering our options, we decided that we wanted to maximize the multi-use of the space, screen in part of it. But when we started down this road, we were sort of unaware that he had built the house right up into to the edge of lot coverage, and as it turns out, beyond. So we're hopeful that our modest request for relief from the board will be acceptable to you all. So that's the first point. The second is about my business. Since 2017, I've run a small business out of our home. It's our headquarters. Since September 2020, about the same amount of time, I think that you all have been doing this virtually, maybe a little bit longer. And around the same time that we realized that we had a need for this deck project, my business has since hired 5 employees. So, we're hopeful that we're going to be able to use this outdoor space for meetings. We want to be able to use it for that purpose. It's important to us. We think that some of our staff may not be vaccinated. So the ability to have a little bit of a larger space to bring everybody together in that way is going to be very important to us. So, lastly, we understand that your staff were unable to find any precedent near us for the setbacks. And we appreciate that the staff put forward the recommendation for an alternate setback, and we'll get to that in the next one. But I just wanted to, again, recognize that we appreciate any relief from the zoning restrictions the board is able to make for us, and we appreciate you hearing our application.
Thank you, Mr. Buskin. Any questions for the applicant? Mr. Buskin, have you seen the staff reports for your case?
Yes, ma'am. Yes.
And you are aware that staff is recommending that we deny the variance?
I'm aware.
Okay. All right. Any comments, questions for the applicant? Again, Mr. Bowen, I can't see my colleagues with that, with the visual up there, so I can't see if anybody's asking for recognition. Thank you. So the standard for a variance is very high. If you've read the staff report, you've seen you've seen what the standard is, and that's the law that we have to follow. Is there anything in the staff report that you think is in error, that in terms of staff's analysis?
No, I mean, we didn't see any errors. Obviously the staff gave it a ton of attention. We brought a number of arguments for why we feel, that our application is sufficient. Obviously, we understand the restrictions that are upon us. Given that the fact that the house was built beyond those restrictions in the first place was something that we were not at fault for that. We're trying to make the best use of the space that we can at this point. And we're a little bit hamstrung because of that. So, I think the staff report was excellently done. They recognized and they sort of addressed all the needs that we have. But the one thing that I would say that I wouldn't have expected the staff to talk about is to get into the details around how we've been hamstrung with what we can do, given the house that we bought.
So it's not uncommon for builders to build up to the max and suspecting owners only realize it after they've made the purchase. That's unfortunately something that we have seen before. But to my way of thinking, it doesn't really provide a justification for granting this relief. But I'm glad to hear from my colleagues. Ms. Freshman?
I agree with your comments and with the staff report generally. I think that unfortunately, we have seen other cases similar to this. And I think if it were so that perhaps there was a replacement because it was falling down, a replacement that was still over the limit, there might be some conceivable relief. But I think just to compound the felony, if you will, by taking something that's already over the limit and then making it larger, I find certainly not acceptable. And given that this is a variance with the high standards, you're not going to find a situation where the kind of exception that the applicant would wish for is really justified. Thank you.
Madam Chair.
I'm sorry, who's speaking?
This is Paul
Oh,
Melnick.
sorry.
Yeah,
Go
so,
ahead.
okay. So I'm in agreement, Madam Chair, with you and with Ms. Freshman. I think, while I appreciate the effort that the applicant has put into putting together the application and the supporting materials, I think that just about every one of the criteria, including unreasonably restrict criteria, the alleviating a hardship criteria, the person with the disability criteria, the acquired in good faith and hardship not being created by the applicant, and also the general and recurring criteria. So those are the ones that I don't think have been met by a preponderance of the evidence. And as Ms. Freshman was saying, even in the the statement of justification by the applicant, they say that the quote is, "The answer we got from multiple contractors was technically it can be repaired," referring to the deck. And so, I just, this very high standard for a variance has definitely, I don't feel been met by a proponent of the evidence. So I can't support it based on what I'm hearing.
Could I respond?
The discussions with the board right now. Let me see if the other board members wish to speak. All right. Mr. Bruskin, did you want to respond to something?
Yeah, I mean, just on that note about the deck being repaired, the response we got from vendors was we could try to repair it. What happens in these cases is that oh, we lose Paul? Oh, he's still there. The response we got from vendors was when they try to repair, they often find that the problems are far worse and we end up replacing anyway. So that's kind of the path that we went. I'm not sure what happened to Mr. Melnick.
Yeah, I mean, I don't either. This is
back.
There you go. This is a difficult situation for us because there are other people that are in your same situation who have decks that currently exceed the lot coverage. And in fact, this board is really restricted from even approving a new deck as a replacement because the county board is not, the way they wrote the ordinance really states that a deck that is over lot coverage can only be repaired, that it cannot be replaced. That's a difficulty that we've run into with other cases where clearly even repairs could not be made. So it really is a limitation of the way the ordinance is written right now. There's I think, pretty good guidance on what a repair looks like, but to actually replace a deck that's over would also be problematic, I think. Mr. Bowen, I don't think anything's changed since. I know you haven't been the BZA coordinator, but we've seen cases before where we were even replacing existing when they're over lot coverage, it's difficult.
No, Madam Chair, yeah, I believe there have not been major updates to the lot coverage and main building footprint requirements since about 2005 was the last time major updates were made. And then Article 16 governing non-conforming features such as lot coverage have been tweaked in recent years, but not in a way that should specifically affect this project.
I think this board would welcome a revisiting of this issue since we expect to see more aging decks that are over coverage, and would like to either have the county board reaffirm that it's their intention that these decks not be rebuilt, or to provide some allowance where they could be rebuilt. Any further discussion on this variance?
Motion.
Ms. Freshman?
I move the Board of Zoning Appeals adopt the attached proposed resolution denying the variance V-11687-21-VA-1.
Madam Chair.
Mr. Melnick?
So maybe we have to wait until it's seconded, but I'd like to make an amendment to the motion with unanimous consent.
I don't think you have to wait till it's seconded. What is your amendment?
Okay. So I reviewed the resolution in the staff report, and I would say that under the whereas clause regarding finding that the granting of a variance will be detrimental to adjacent properties. I think we ought to change it to will not be detrimental. Because that's the one thing I didn't think was an issue, is whether it's detrimental. But the rest of the criteria wasn't met. But so would Ms. Freshman be willing to say will not be detrimental?
So this is, are you asking for unanimous consent?
Yeah, just to change the motion, or
if-
just take.
If you're asking for
Or we can
unanimous
always-
consent, I
Yeah.
personally wouldn't agree with that. That's all. So you'd have to put it as a motion, that part of it.
Okay, so I make a motion that
But
that
but then
paragraph.
Motion on the
if
floor.
we're gonna do that, we gotta figure out whether we're gonna second Ms. Freshman's motion.
Okay, that's fine.
Is there a second to Ms. Freshman's motion?
A second.
Okay. Okay, there's a motion made by Ms. Freshman, seconded by Ms. Arthurs to deny the variance. Now, Mr. Melnick, you would like to make a motion, a substitute motion, amend the motion?
Yes, I'd like to make an amendment to the motion, that the whereas clause that states the BZA finds that the granting of a variance will be detrimental to adjacent properties, semicolon, and I'd like to change that to whereas the BZA finds that the granting of a variance will not be detrimental to adjacent properties, semicolon, and.
Okay, is there a second for that motion?
Could you explain your rationale?
Yeah.
Well, I don't think that, so I'm not seeing that granting this would be detrimental to the neighbors. I don't think that that's an issue. And so that's my point. That's for me, and from our discussion, I didn't see that the criteria about it being detrimental, that wasn't met. So that's just to be clear about the criteria, which ones were met and which ones weren't.
Mr. Rissi, do you have your hand up? Mr. Bowen, do you have your
Yes,
hand up?
Mr. Bowen. I do have my hand up just to say that staff is not opposed to Mr. Melnick's motion. I think we intended to have that language read as such in the staff report, and the fact that it doesn't is a clerical error on our part.
And Mr. Rissi, are you just echoing Mr. Bowen? Yes.
Mr. Bowen is using Mr. Rissi's hand because they're still playing musical chairs.
He's off camera, but he's nodding.
In that case, then I second Mr. Melnick's motion.
All right. Seconded by, so
This is an amendment?
yes, first we're going to vote on the amendment. And if
Okay.
the amendment carries, then your original motion will be voted on with the amendment. So Mr. Melnick has made a motion, seconded by Ms. Arthurs, that granting this variance would not be detrimental, and has adjusted the language. I will call the roll. Mr. Melnick?
Aye.
Ms. Freshman?
Aye.
Ms. Clark?
Aye.
Ms. Arthurs?
Aye.
Chair votes aye. So the motion to amend the main motion carries 5-0. Now we'll vote on the main motion, which is to deny the variance with the amendment that Mr. Melnick just made. Mr. Melnick?
Aye.
Ms. Freshman?
Aye.
Ms. Arthur?
Aye.
Ms. Clark?
Aye.
Chair votes aye. So I'm sorry, the motion to pass, to grant the variance fails 5-0. Mr. Bowen, will you call the use permit?
Yes, Madam Chair. The use permit is in fact the use permit associated with this same variance request for the same property, and I will read that now. It is V-11687-21-UP-1, a use permit request by Jonathan and Laura Brushkin, the owners, to permit a rear setback of 15.3 feet to the screen porch and deck, 14.3 feet to the porch eave, instead of 21 feet to the screen porch and deck, 19.5 feet to the porch eave as required, regarding a new rear screen porch and rear deck to an existing one-family dwelling in the R8 zoning district on the premises known as 6201 30th Street North. Staff recommends that the board adopt the attached proposed resolution denying the use permit request. Two alternative resolutions and petitions have been provided should the BZA see fit to approve the application as advertised or with a minimum rear setback of 16.5 feet, comparable to other surrounding properties identified by the zoning division staff.
Thank you, Mr. Bowen. Any questions for staff? I have one. This use permit cannot be built according to what's being proposed without the variance that was just denied. Is that correct?
Yes, Madam Chair, that's correct.
Okay.
Madam Chair,
Ms. Freshman.
does that include your alternative resolution 2? Which has,
Yes, it does.
so regardless of the alternatives suggested, none of them can be built without the variance?
Correct.
Okay, then.
Yes, due to the non-existing total lot coverage and total main building footprint not being met, they would need the variance for any of the use permit features as well.
Right.
Okay. Mr. Bruskin, you've heard the discussion. Do you have anything you'd like to add?
Well, there's nothing that we want to add necessarily other than, in discussions with Mr. Rissy and in our reading and understanding of this process, we understand that the tests for the variance are tougher than the use permit. However, it's a little hard to understand why there would be a recommendation that would be inconsistent with a recommendation for denial on the variance. So we certainly get the distinction between the two, but it's just a little bit hard to follow. Now, that being said, there is an alternative for a smaller deck. We have plans for an even smaller deck and with screened-in porch that would cover only the existing footprint that we did not submit, that we would like to submit if the board would defer both applications to the next meeting. Understanding that if we're already over lot coverage, that there would have to be a discussion about whether we could get approvals for just replacing the existing deck or even replacing the existing footprint with a screened-in portion of the deck. But we'd at least like to have the opportunity to have that discussion using an alternate plan. And so if the board would defer both of these for another month, we would be able to resubmit the application. That was something that I discussed with Mr. Rissy. I tried to make a comment before you all voted just now, but our time had expired and I didn't have another opportunity to say that.
Ms. Freshman, do you have your hand up?
Yeah, my issue is, it goes back to one of the things that the chair said about not being able to replace something that is within, because it's already over coverage. And so I'll defer to my colleagues, but I believe that we were correct in denying the variance, and absent a variance, then there might be 3 or 4 different proposals brought in, and it would be unlikely, unless it was a very, very small deck, that the criteria could be met.
Mr. Bowen, regardless of what deck they brought in, regardless of the size of the deck that they would propose, they would need a variance.
Yes, Madam Chair, I believe they are over lot coverage by close to 5% as it stands. So there's really not much to be done by right or with even a smaller deck.
Right. There's no, they don't have a by right option to replace their deck or to build a smaller deck. And in order for us to grant a use permit, I believe we would have to grant another variance.
Any deck over 4 feet in height of this size would count towards the main building footprint and total lot coverage.
So their best option at this point would be repair. That would take them out of this process entirely.
Yes, repair is certainly one option.
So, Mr. Breskin, we're having trouble seeing what alternative you could bring back to us that would be approvable.
I understand. I mean, this is the hand that we've been dealt, so we're trying to do our best here.
Yeah, so are we. Unfortunately, we're trying to follow the law as we've been charged to do here. Any other comments on the use permit? Okay, can we move to a motion?
Yes, ma'am.
Ms. Freshman?
I move the Board of Zoning Appeals adopt the attached proposed resolution denying the use permit B-11687-21-UP1.
Second.
Seconded by Ms. Arthurs. I will call the roll. Mr. Melnick?
Aye.
Ms. Freshman?
Aye.
Ms. Clark?
Aye.
Ms. Arthurs?
Aye.
Chair votes aye. Unfortunately, this is something we'd love to see clarified, but as things are stated for us right now, this is where we are, unfortunately. And I will say the clarification would be with the county board. That's who would make the clarification. So we're going to move on to the next case. Mr. Bowen, will you call that one?
Yes, Madam Chair, sorry for the delay. I'm sharing and unsharing the screen. Takes just a moment. The next case on our agenda is V-11, excuse me, sorry. I believe we approved the very next case. Yeah, we're actually missing the case in our packet, so give me just a moment. Okay, the very next case in our packet is V-11688-21-UP-1, a use permit request by Brian and Denise King, the owners, to permit a street setback of 17.2 feet to the porch, 16.8 feet to the porch eave, instead of 21 feet to the porch, 19.5 feet to the porch eave as required, regarding a new front porch addition to an existing one-family dwelling in the R6 zoning district on the premises known as 1829 North Kisada Street. The staff recommendation is to adopt the attached proposed resolution granting the use permit request with conditions.
Thank you, Mr. Bowen. Any questions for staff? All right. Is Brian or Denise King with us tonight?
We are.
We are.
Welcome.
Welcome. Thank you.
Is there anything you'd like to add to your application? Anything you want to tell us about?
No, just that you can see we're drying our bath mats out there. That, we have been wanting to add a porch for a while. This is something that we, our house isn't very big and the front door goes right into the living space. And we want to add a porch so that we can, move some of the stuff, things like shoes and stuff out onto the front porch. And also we have a mail slot, which was from the original owners of the home, and we would like to put a mailbox out in front. And it is definitely, it is in line with the other homes in our neighborhood. As you can tell, we definitely are one of the smaller homes in our neighborhood, soon to be even so with the home that's being built next door to us. So we would just like to add this porch on to increase the value of the property, and also we will plan to use it quite a bit.
Thank you. Any questions for the applicant? So, the reason, as you saw, there were a group of applications that we approved in a batch because they were complete, but yours was not complete, and that's why we're hearing it now. And what's
Confused by
missing?
that. Go ahead.
I'm sorry.
I saw the comment that you needed the plat that showed the, is that correct? That shows the proposed porch?
No.
Is that what was
No.
what's missing?
No.
Oh,
No.
okay.
You're missing neighborhood input, neighbor input.
That was
That
provided,
was provided.
and it's in the, it was provided, and it's also in there.
I'm showing 3 signatures. Is that what you're looking at?
Yes,
Now you have neighbors also on the other side of your house and behind you, right?
yes, we submitted a response to that via email to Blake. The neighbors to the, if you're looking at the picture on the screen right now, the neighbors to the right of it, that house was sold in June to an investor. It's been vacant since June. We have no idea who the owner is, and that house is being torn down.
So yeah, there's no way for us to go ahead.
I've just, Mr. Bowen, did you receive this correspondence that they refer to?
Yes, Madam Chair. In the last page of your packet should be an email from September 15th.
Oh, that's what it is. Okay. All right. Here's when we had provided some information on neighborhood outreach, and it's called the BZA's Guidance on Neighborhood Outreach. And in your application, you had checked that you had read it. In that, do you recall that?
You must have been.
I must have.
Yeah.
I was the one that did the application.
Now in that guidance, it explains what to do if the property's vacant or if there's a tenant. Did you see that part?
I don't recall.
Yeah, you must.
Yes.
I don't remember seeing that. I was told that we needed to get a signature, or support from 3 of the neighbors. I didn't realize it had to be every.
Where did you get the idea that it was just 3? I'm asking because I want to make sure that our instructions are very clear, but because our instructions.
Well, it's been such a long time. I don't.
Did
I
you
don't recall,
not
but
get a letter?
I had the idea. I think it may have been. I don't recall exactly. I thought it was 3.
Did you get a message did you get an email from our BZA assistant just maybe a few days ago asking about we
got an email asking about the 2 homes.
The 2 homes, and that was the email we responded.
And we responded to that.
I see.
And that was our response was, and perhaps in our ignorance, it was both of them were vacant, and the one home, like I said, is sold to an investor. Don't even know who it is, and then the home behind us is also vacant and is a rental property. And again, of course, we could do our due diligence and find the owner. I have no idea, who that person is, but we can do that certainly.
So, all right. So we're always trying to improve our process and make sure that our instructions are clear. And we're just looking for ways to make them more clear so that people do have a chance to submit a complete application. Any other discussion?
No, I guess our question would be, and I guess we'll wait for further, would be that do we need to seek out from these individuals? I don't really think the investor even lives in the area, whether it would be permissible to have this setback for the porch.
Let me just discuss it with our, put
Okay.
the discussion to the board,
Sure.
see where we're at on this.
Sure.
But we appreciate your feedback on our guidance.
Madam Chair,
Mr. Melnick?
I feel like this is a rather modest improvement, and it's actually on the, look from the street on the left-hand side of the property. And I understand about neighborhood outreach and the importance of it. And, you know, just, I think that it does sound challenging as far as like reaching the owners of these properties being vacant. So just in light of what we've seen and the nature of what's being proposed, I'd be willing to make a motion to approve it.
I agree with Mr. Melnick.
And I
You have
do
the
too.
floor. Okay, let's proceed.
Okay, so I'd like to make a motion. That's fine. Okay, so in case V1168821 UP1, I'd move that the Arlington County Board of Zoning Appeals adopt the attached proposed resolution granting the use permit request with the conditions as stated.
Second.
I'll second it.
Oop, I got 2 seconds here. Who's seconding?
Draw.
So seconded by Ms. Clark. All right. Thank you. We have a motion made by Mr. Melnick, seconded by Ms. Clark to grant the use permit. Is there any further discussion? I'll call the roll. Mr. Melnick?
Aye.
Ms. Freshman?
Aye.
Ms. Clark?
Aye.
Ms. Arthurs?
Aye.
Chair votes aye. Motion to grant the use permit. It passes. You have your use permit and can go ahead, build your porch.
Thank you.
Great. Thank you.
You're welcome.
Thank you for your time.
Thank you.
Thank you. Next case, Mr. Bowen.
Madam Chair, the next 2 cases were actually approved in the group motion at the start of the meeting. That is V-11689-21-UP-1, as well as V-11690-21-UP-1.
I think we're at 93, right?
Gotcha. Okay, so in that regard, I will be handing over the computer
All right.
reins to a familiar face. Mr. Rissy will be handling the second half of the meeting.
All right. Thank you, Mr. Bowen.
Thank you.
Just to follow up on what Mr. Bowen said, in addition to the cases he called, case V-11691-21-UP-1 was moved with the group motion, as was case number V-11692-21-UP-1, which brings us to case V-11693-21-UP-2. You'll give me just a second to advance our PowerPoint to that slide and bring that up on screen. There we are. All right. This is case number V-11693-21-UP-2. It is the use permit request by EWF Loan, the owner, to permit a rear setback of 18 feet to the screen porch, 17.5 feet to the porch eave instead of 25 feet to the porch. 25 feet to the screen porch, 21 feet to the porch eave as required, and to permit a left side setback of 6.9 feet to the screen porch instead of 8 feet to the porch as required, regarding the proposed rear screen porch addition in the existing one-family dwelling located in the R6 zoning district on the premise known as 1401 North Sycamore Street. Staff recommends the board adopt the attached proposed resolution denying the use permit request. An alternative resolution has been provided should the BZA see fit to approve the application as advertised. .
Thank you, Mr. Rissy. Any questions for staff? All right. Is Ms. Flom with us tonight?
Yes, I am. Hello.
Hello,
It's
welcome.
I see you avoided the first name. It's Eva, like forever and ever.
I mispronounced it. I apologize.
Oh no, that's perfectly fine. It's my icebreaker. Thank you.
Is there anything you'd like to say on behalf of your application?
Well, I too would like to really commend Mr. Bowen and Mr. Stephen Rissy for all the help they provided in understanding the process and just answering so promptly all my questions. That was a tremendous help in getting through this process. I also, as I'm preparing and listening to the others ahead of me, was taking a look back at some of my information, and there may be a slight error, or not error, but as you can see from the one picture that shows the lot, there is a little bit of a slant on the back side of the lot. And so for the information I had, I understood the setback to the house being 27 feet, but I rely on the staff report mentioning that it's 25 feet. I know the requirement is 25 feet, but I think I have 2 extra feet back there, but that's the only thing I would add to that. I would say that, as the report points out, I'm essentially asking for putting a screen porch over the space that is occupied by the air conditioning units. So it's pretty much not really usable for my family. Otherwise, that ground area in the backyard. This is an older home, a small lot, and I'm just looking to find a way for my family to be able to enjoy all aspects of the home. As mentioned in my application, I do have a multi-generational family here. My mother is living with us, plus 2 teenage daughters, and having that screened-in porch area would be very helpful in just having a little bit more flexibility in using our home. I also have, I'm sorry, I also have Mr. Jeff Kelly, who's the contractor, in case there are any more specific questions on my project.
All right. Any questions for the applicant?
Madam Chair?
Mr. Melnick?
I have a couple. First of all, the structure on the survey plat, that it looks like it's in the corner. It looks like it's a little stoop or something. It's entitled BE. So what is that structure?
There is just a small shed.
Oh, okay. What does BE stand for? Do you know?
I'm sorry, I'm not sure what you're referring to.
Oh, it's in the corner.
There's a hand raised.
It's right on the corner of the patio where the house has the corner in it.
Yeah, I see that.
Looks like
too.
Stephen might have the answer for us.
Mr. Rissy, you?
BE typically denotes the basement entry or the areaway, the entry to the basement.
Yeah.
I see.
Yes,
Okay.
the way to enter my basement is through the outside.
Okay, because my next question was going to be, just in light of the setbacks and, of course, what we do when we see that what you want to do goes over the setback lines, we look for other options and ask you about that. Because my question was going to be, did you investigate putting the screen porch into any of the area occupied by the patio currently? And I see if there's an entryway to the basement, that could be an issue. But did you investigate any other places to put this except where it is, where it goes over the setback line?
I understand. The area where the patio is and everything, it's a big drop. There's actually a retaining wall there. And so it really wouldn't, I did actually look into having maybe a sunroom there or something like that. But it was very cost prohibitive and would require a very large project to move any of that ground and rework all kinds of drainage and things like that. It would be very disruptive. And trying to remember my train of thought here. And the other part of it, the reason why I thought this would be the better place as well is because I am not looking to have any steps coming down from that screened-in porch. The exit and entrance would come off the window that you see on the left. That's even with the floor level of my home, so that would be the above the second floor one. Yeah, that's where the entrance to the screen-in porch would be, and it just fits with the architecture of the house. I also, you know, an 8-foot deep porch is not really big. I was encouraged to look for larger, you know, maybe using more space, but I really didn't want to do that. I didn't want it to overpower and be better in scale with the rest of the house. And also that this way the posts would be right along the side of the air conditioning units there, and basically helping to enclose that area as well, and only have the overhang past that. So I did put some consideration into that this would not look awkward and be buildable.
I think, Miss, are you done, Mr. Melnick?
Yes, I am for now.
Okay. JF, is that your contractor?
That's Ms. Freshman.
Jeff Kelly.
Did you wish to add something?
Ms. Freshman has her hand up, Madam
Oh,
Chair.
that's Miss Freshman.
Yes.
Sorry, Miss Freshman, go ahead.
Yeah, in keeping with other discussions you've already heard about neighborhood outreach, there are two, your proposal is on the rear of your house, and there are 3 dwellings on Roosevelt Street that would be impacted by that. And we have a signature from 1400, but not from 1304 or 1404. Can you enlighten us about that?
Yes, certainly. So the property just behind mine, which is Mr. Callahan, he is the first one that's signed on Roosevelt Street 1400. He is also the owner of the house to the left in the rear. That is also his property. So I kind of assumed that would take care of both those. I could have asked him to list both addresses. As far as the property to the right, I could reach out to them. I just didn't because there is a lot of obstruction, the large trees, a lot of brush. I cannot see their house even in the winter, and they cannot see mine. And so it didn't occur to me to ask for their assistance in this and supporting my application. I also, when I had the second floor addition, I was not required to seek the approval of those neighbors. So it just wasn't on my radar. The assistant that you have did reach out to me, and I appreciated that assistance to also check with my neighbors in the front on Sycamore Street. Again, the only reason I hadn't initially asked them was because I just didn't think a back porch would affect them, but they were more than happy to endorse my project.
Ms. Flom, so you built a addition to the back of your house you mentioned? But
no, it's the second floor.
I'm sorry?
It's the second floor. That was built. Yes.
You built, but was that done by right? Because
it was done by building permit.
Yeah, you mentioned that you weren't required to get signatures. I think that must have been by right. I don't see
right,
it.
yes.
So in that case, you would not have needed any signatures.
My apologies, yeah.
Got it. Okay. Have you seen the staff report?
I have.
Okay, and you're aware that staff was recommending that we deny the use permit?
Yes, and my understanding was that there's no adverse, they agree there's no adverse Sorry, my brain's a mess now. There's no adverse effect on the neighborhood or public welfare and those types of things. But their concern is that the setback I'm requesting is not evident nearby, as I understand it. Again,
Yeah, one of the criteria that we use for a use permit is simply compatibility. And by compatibility, we really mean, is it like what your neighbors have, or is it very unusual from what your neighbors is? And that is a judgment that we make. And what staff does is it looks at properties nearby to see if it can find other properties that are like yours or like what you've requested to answer whether it might be compatible. All right. Any comments, questions from the board?
Madam Chair.
Mr. Melnick?
So in line with what you were saying, Madam Chair, what I'd like to ask the applicant is, like on the staff report, it looks as though under porches, the closest one found about 50 feet away was 27 feet away from the rear line. And then other structures, a rear deck was found 21 feet from the rear line, and a dwelling wall was also found 21 feet. And so in light of this, the fact that we can only approve something if it is compatible, is there any modifications you can make to bring it closer to these amounts, to bring it further away from your rear line? Because, this isn't, at least for me, it's, we use reason, we try to be reasonable, but we have to follow the law and we have to look at compatibility. But if push comes to shove, are there any other options to make this less deep, where it can be brought further away from the rear line? Anything like that?
Jeff, I'm sorry if you're on there. Again, this is my contractor. Is that, I'm not sure what that does to the project if we were to make it, what would it be, like a 6-foot depth instead of 8 feet depth?
Yes, good evening. I'm Jeff from Northcraft Builders. And along that same way, I was just going to ask if maybe the board could explore some of the alternative recommendations it made, or I should say the BZA, make the alternative recommendations so that we can get an understanding of what our options are at this point, because I know it was approved. It was denied, but then it was approved with options. And I just wanted to figure out what you're exactly telling us in that.
Mr. Rissy, go ahead.
I could clarify that. Mr. Kelly, with the staff report, we gave a recommendation, and the recommendation was denial. But whenever we give a recommendation of denial, we also give the board at least one alternative resolution. If they choose to, they can adopt the alternative resolution, and that would be approval as advertised. So we just kind of craft the motion so they don't have to come up with a motion on the fly at the meeting. So they have two options tonight. They can choose the denial, or they can choose the approval, or they could, defer or modify. But those are just staff's giving the board a kind of heads up on the ability to make the motion. So they haven't adopted either one of those yet.
I see. I understand. I misunderstood that. Okay.
No, thank you for making that.
And I guess the only thing I would, yes, thank you. I guess the only thing I would point out is maybe there is, as I mentioned, there might be a little discrepancy in exactly how many feet are from the back. I don't know if the BZA staff took the measurement or anything.
Mr. Rissy, I know the lot is angled, and I believe you need to take the most conservative number. Is that correct?
That's correct. And I'll just say for the applicant, we didn't go out and measure independent. We did rely on the measurements you provided with the proposed plat that showed the 18 feet.
But you
That
made,
is-
Yeah, and again, this is from my notes. I had it shown as 27 feet.
Where, are you looking at the plat?
Madam Chair, I believe she may be referring to the existing conditions, and that was an estimate based off of software that we have. And so that's probably the difference in the 2 feet that we're talking about. I think we said it was approximately 25 feet from the rear, and I think the applicant is suggesting that she believes it to be closer to 27 feet from the rear. So that only affects the existing condition, does not affect the proposed condition that the applicant has requested.
I see. I see. Got it. So, I guess the question that Mr. Melnick put to you was, do you see any way that you can bring this more into conformance?
Again, I think it sounds like I would be able to, is it that I would be able to do it with 4 feet, but then that's not really a very usable space. So, asking for, rather than another 4 feet, asking for just 2 feet to make it a 6 foot wide area. I mean, depth wise. But then again, as I mentioned, I guess I'd want to make sure that we have the correct existing conditions to know whether that extra 2 feet is actually there or not.
Okay,
I mean, I'd be
Ms.
willing
Freshman,
to
Madam Chair.
get to 6 feet.
I have Ms. Freshman has her hand up.
Okay.
I had one comment and one question. On the technical question, is the HVAC going to remain there if you build a porch and just remain underneath it? So you're not relocating that anywhere into the side setback? Okay.
No,
I
ma'am.
think, as a comment, I would just say that having been a builder and user of porches forever, 8 feet is about as much as you could get away with in terms of having it be worth it and usable. So I think the question really is, if this is the only place that can go, can we live with the considerably reduced setback because of the angle of the property? And that is a mitigating factor in my view.
Right, any other comments from the board? Want to test a motion?
Mr. Rissy?
Yes, go ahead.
Madam Chair, I don't want to confuse the matter any more than it is already, but I do want to point out just some clarifying marks on the way that we wrote the advertisement, in case anyone is unclear. We wrote the advertisement as a request for a setback of 18 feet rather than 25 feet. Typically, porches are given a 4-foot encroachment allowance into the 25 feet so long as they do not exceed the first level of the structure on interior lots. We couldn't confirm that this first level wasn't considered a first floor. We think it might be, which is why we advertised it as 25 feet. But I would like to point out that there is opportunity for some porches to be as close as 21 feet, which would make the requested encroachment smaller than it seems given the advertisement the way it's written.
Thank you.
Oh, Mr. Rissy,
Thank you.
I think we need to deal in what is, right? So how do we work with possibility?
I don't think that's a possibility, Madam Chair. I'm just trying to explain why you see the advertisement the way you do, why you see a request for, a 7-foot encroachment where you might, other porches, maybe even this evening, rear porches may have needed less because they were said to be required to be 21 feet. It's not an alternative. I'm not proposing they drop it down to the first level. I'm not
proposing anything alternate from what is. I'm just trying to explain the reason the request is the way it is.
All right. Thank you.
Madam Chair,
Mr. Melnick.
so does the architect have anything more to say about any other options? Because, just so we can consider everything, sometimes if there are other options, we defer and then the plans are redrawn to bring it, a little closer, and then it's heard at another meeting. And it sounded like there could be other options, but I just wanted to make sure we're hearing everything. So, what are your thoughts?
Well,
as
actually,
far as that.
yeah, actually, the two things that I was thinking have actually been said, Mr. Rissy, about asking for the 18 when we can get into 21, which we do on a regular basis with rear because of the 4-foot allowance. So I appreciate him bringing that up. And then also the other comment is, once you get smaller than 8 feet, what is your cost value there, and how difficult it is to have a family enjoying a space that is 4 feet or only 5 feet out from the house when you can barely put a couple of chairs and walk by something there. So as far as alternatives other than those two things mentioned, I'm not really sure. I'd have to go back to kind of the drawing board and see. I certainly would want to verify the 27 versus the 25, because then we're getting a lot closer. But those are the two things that I was thinking about that have already been mentioned. So I'd have to go back to the drawing board on any alternative designs or plans.
Okay, thank you.
Yeah, sure.
Ms. Arthurs?
As a person who also has a very crazy slant in my lot, I am prepared to make a motion if my colleagues are.
You have the floor. You can make a motion at any time.
All right. I move the Board of Zoning Appeals approve the attached proposed plan. Oh, wait, shoot, you guys denied it. I'm not prepared to make a motion.
Yes, you are. Look at the alternate.
The alternate,
resolution.
okay. I move that the Board of Zoning Appeals approves a special use permit case V-11693-21-UP-2, subject to the following the conditions listed in the proposal.
All right, in case number V-11693-21-UP-2, correct?
Mm-hmm.
Okay.
Did I say it wrong?
I wasn't sure if you had said the whole number.
I'll second.
All right. We have a motion to adopt the alternate resolution, which is approval as advertised. Is there any discussion?
I would just make the comment that I do think the rear lot line is a mitigating factor, as I said, but I also think that if there was really a viable alternative, like slightly smaller or in a different place, then maybe a deferral to rework it would make sense. But I don't see that in this case. And which is why I have supported the motion.
Any other discussion? I will call the roll. Mr. Melnick?
Aye.
Ms. Freshman?
Aye.
Ms. Clark?
Aye.
Ms. Arthurs?
Aye.
Chair votes aye. The alternate resolution is adopted 5-0. Build your porch.
Thank you.
Thank you so very much for your time on this. Thank you.
All right. Thank you for your patience. All right. Mr. Mr. Rissy, it's Mr. Rissy still with us. Okay. We're going to hear the next case, which is an appeal. Does anybody need a break? Because that takes a little bit longer. Are we good to
Madam
go?
Chair,
Wow. Did
Madam
I
Chair,
freeze?
I could use a short break.
5 minutes?
Let's do a 5-minute
Sure.
break and then we can get all the parties ready.
Okay.
Got the clock on.
I'll start the clock.
Thank you.
Madam Chair, I don't know if you're still with us, but it appears your video is frozen.
Nine 9:30 is good.
Mr. Rissy? You're muted.
Yes, Madam Chair.
When I look at my screen, I am frozen.
That's the same on mine.
Are you
I might
frozen?
try-
Shall I come back?
I would try just turning off your video and turning it back on to see if that resets you.
Okay.
I'll also note that Miss Arthur still appears to have her hand up. Got 2 things. Just taking her hand up.
Were you talking about me?
Never.
You had your hand up. All right, now I restarted it. Now it's no picture.
See no picture.
Yeah, you've been frozen for a while on my screen, actually.
Yeah.
You were pondering something, though, so it was a good look.
Yep. Thank you. Very good. Shall I exit and try to come back in?
Sure.
We got time.
Okay. Probably.
I see motion.
Back and unfrozen.
Right. Now your clock is frozen.
I paused it.
Oh.
I have to reset it for 20 minutes anyway.
Okay. Are we all back?
I don't see you, Inta.
I see me.
I see
Judy, I
Portia.
haven't seen you in a while.
Yeah.
Who? Me?
How are you
No, I haven't
doing,
seen
Portia?
Judy in a while.
Yeah. Would you take the picture down for a minute? Let's see. All right. I don't see Judy.
Yeah, I don't think your camera's on, Judy.
I don't see Paul.
Yeah, it
No.
is. I'm down in the corner.
There I am.
There's Paul.
There's Paul. I see Paul.
Paul,
I
we've
don't
only seen you from the nose down all evening. I think you're close. Maybe
What?
you're
Oh, I see like all of his tie.
He's got a vertical. Yeah.
I can't see him. That's
Wait,
weird.
maybe Judy, maybe you should go out and come back in.
That's okay. If I can only see his nose and mouth, that's all right. I know who he is.
All right. Okay, we're all back. Mr. Rissy, are we ready for the next? Everybody ready? Let's call the next item.
Yes, Madam Chair. The next item is case number V-11696-21-APP-1. It is an appeal by Anita DiPietro, the agent on behalf of the Malloy Family Limited Partnership, the owner of a zoning determination addressing the multiple family residential use of a building located in the R6 zoning district on the premise known as 520 North Garfield Street. Staff recommends that the board adopt the proposed resolution affirming the zoning administrator decision.
Thank you, Mr. Rissy. I understand that we will start with a presentation from the zoning administrator.
Good evening. I have a very brief set of remarks. I'm joined by Kevin Black from the County Attorney's Office, so if there's something that I miss or forget, he will follow up, and then after we'll be available for questions. So just to summarize why we're here, the appellant requested a determination on March 18th of this year regarding the use of the subject property at 520 North Garfield Street, located in the R6 single-family residential zoning district for multiple family dwelling. Determination was issued on April 22nd. That determination stated that the existing multiple family use on the subject property is not permitted. The records on file in the zoning division office indicate that the existing improvements on the subject property were constructed between 1962 and 1964, at which time the property was zoned R5. At that time, the R5 zoning district allowed duplex dwellings, defined as a two-family dwelling with one dwelling unit over the other, having a single front entrance or one front and one side entrance on the first floor level, and all exterior characteristics of a one-family dwelling, and those duplex dwellings were allowed by right at that time in the R5 district. Historic house cards for the property indicate that the original use of the building as was a duplex, and current real estate tax assessment documents describe the existing improvements as such as well. In 1964, the subject property was rezoned to the R6 zoning district, and the duplex was made non-conforming. The appellant has provided copies of real estate listings and lease documents as evidence of the prior use of the subject property as a multiple family dwelling, which the Arlington County zoning ordinance defines as a building or portion thereof designed for occupancy by 3 or more families living independently of each other. However, none of the documents provided indicate zoning approval of the establishment of a third dwelling unit on the subject property. To some, the existing building was constructed as a duplex dwelling, which was a permitted use in the zoning district at the time it was established. Since that time, a rezoning of the property has rendered this a non-conforming use that may remain so long as it meets the requirements of non-conforming uses found in Article 16 of the Arlington County zoning ordinance. The record contains no evidence of zoning approval of the establishment of a multiple family dwelling at the subject property. And because multiple family dwellings are not a permitted land use in the R6 zoning district, any use of the subject property for that purpose is not permitted. Staff requests that the BZA uphold the zoning administrator decision in the April 22nd determination. That's all for me.
Thank you, Ms. Vaughn. That concludes your presentation.
Yes.
All right, let's hear from the applicant.
Hi there. Thanks for taking the time on this. This is definitely a unique situation for me. I'm not sure if it is for you. My name is Anita DiPietro. I represented the purchasers in this transaction. We purchased the property fall of 2020. You know, I thought I had done a fair amount of due diligence on the property, given it was currently being used as a 3-unit multifamily and had been used as a 3-unit multifamily since as early as 1995. You know, the past two times it had been sold within the last 3 decades have also indicated it for sale as a 3-unit multifamily property. So going into this, you know, we assumed we were buying a 3-unit multifamily property that just was grandfathered in. And the current or the previous owner, the seller in that case, had, you know, reassured us as such, given the utilities were set up, you know, the 3 multiple units were already separated and, you know, renovated and all of that. So we were a little surprised several weeks later to receive, you know, a letter from Arlington County Zoning, essentially stating that the property was not to be used as a multifamily 3-unit. And we've been trying to sort this out ever since, really. So I guess I just kind of wanted to give a little bit of history, a little bit of background on how we got here. And hopefully, you know, hopefully we can come to a resolution, you know, here, because the property is tenanted and we're kind of, we feel like we were duped a little bit. Not your fault, obviously. I know Arlington County zoning doesn't have anything to do with that, but I guess the main concerns I have are just the use of the property over the course of the last, you know, 30 years, and why are we, you know, the current owners, why is this being brought to our attention now? So I have a couple questions kind of once we get started, but I just wanted to give a little background.
Thank you, Ms. DiPietro. Does that conclude your presentation for now?
Yes, ma'am.
Thank you. Mr. Rissy, could you take the picture down so I can see people again? Thank you. Ms. DiPietro, did you have video? Was I the only one that was not able to see video for you?
I do have video, yes.
I don't see her.
I don't see you either.
Oh,
Is your camera on?
yeah, yes, it is, according to my computer.
All right. Okay. So we've heard both from both parties, and I'm going to start with allowing any questions that you may have for county staff on this issue.
Madam Chair.
Mr. Melnick?
Okay, so I have a preliminary question. And this has to do with, let's see, Miss DiPietro acting as the agent for the applicant. Because I was looking at the agency documents, and the first one, looked like it doesn't look, according to the signature of John Malloway on the second agency document dated July 7th. So the one that's entitled owner consent agent authorization, but that says it's for an application for a special permit. And it looks like it was superseded by the one July 7th, but it states that this authority for Ms. DiPietro to act as agent was given by Mr. Malloy as sole member of 318 G Street LLC. And I'm wondering, what is the 318 G Street LLC? So how did he, as sole member of that, give authority to Ms. DiPietro to act on behalf of the owner of the property? Does staff know the relationship of the different entities? So does it look like there's a good connection there to give proper authority to Ms. DiPietro to act on behalf of the applicant?
I'm going to defer to Kevin to respond to that question.
Mr. Black.
You. Yes, this is Mr. Black. Mr. Melnick, yes, I did look into that issue, and I was satisfied as to the authority for Ms. DiPietro to represent Malloy in this case. I understand why you're asking the question. There's an additional, we actually had requested additional documentation, and upon reviewing that documentation, I'm fully satisfied that she has the authority to represent them.
Okay, thank you.
You're welcome.
Ms. Freshman?
Yeah, could you just clarify for me how this came about? Because I was a little unclear. The real estate transaction assumption that it could be 3 units and had been for some time. But I mean, typically sometimes we get cases that are a result of a complaint or some other issue. I would have thought that would have been a clarification prior to purchase. But in any case, if you can enlighten at all on how we actually got to the point where a determination was requested or ordered.
I can answer that if you'd like.
Who was it directed to, Ms. Freshman?
Well, either the applicant or the staff, whoever can tell me how we got to this point that we're now discussing it, because it just was a little confusing to me that the county was asked for a determination. And I think I understand who asked it, but the timing vis-a-vis the purchase was a little suspect to me.
Correct. The after purchase, we received a letter in the mail at my office. This is Anita DiPietro, just in case you can't see my face. We received a letter in the mail, essentially from Arlington County, stating that an inspection had been done, and that we were essentially operating in an illegal apartment building, which was new news to us. So I had called the inspector at the time. I believe his name was Richard Gum. And I had spoken with him about what had happened and why we were being cited. And he was the one who initiated that I file a zoning determination letter for the property.
So it was during the course of a building inspection or zoning inspection? And maybe this is to staff. Is Mr. Gum a zoning inspector or a building
Yes.
inspector?
He's a zoning inspector.
Zoning inspector, okay.
But what would trigger it? What triggered it? Do we know? Is it just a routine once every 5 years we go to every building or? I mean,
No, I don't have the details, but we are overwhelmingly, almost wholly responsive to complaints. There are very few things that we proactively investigate. So that would be my.
That was my assumption, but there wasn't any indication that in the report that it was in response to a complaint. Thank you.
Well, because the determination was in response to a determination request. It came in the determination request was a fairly straightforward application process. That didn't actually refer to an enforcement issue at all.
Okay, thank you.
Miss Arthurs, did you have your hand up?
I did, but my dog is losing her mind outside with the UPS guy right now, so I'll just wait a second.
Okay. All right. So what would, this is a little confusing to me. What would happen if we found that the zoning administrator had erred? I mean, can the Board of Zoning Appeals declare that this is a permissible use? Is that?
I don't believe so.
Use your words.
Yeah, I'm sorry. I was trying to check in. No, they can't. They don't determine matters of use, so they cannot.
Also, in a letter that the applicant sent directed to the Board of Zoning Appeals, they asked, I'm trying to find the letter, but they asked that they were asking for a variance. Is there, this hearing is not about a variance. Is there any variance that they could put before us? So a variance that would not be a remedy under any circumstances.
No.
Okay. All right.
Could I ask another question?
Sure. Who is speaking?
Okay. Yeah, Freshman.
Ms. Freshman, thank you.
So, as Mr. Black has said, we don't have the authority to legalize, if you will, this use. And if that's the case, I mean, as a board, so if that's the case, what's the result if we don't find for the zoning administrator? I mean, I don't understand how you get from A to B.
Mr. Black, I think that's directed to you.
Well, it's my opinion and staff's opinion as representing staff as well, that in order for this to be a legal use, it would have to be in the zoning ordinance already in this district as a permitted use, and it is not. And so if you were to make a determination based on use, effectively either ignoring or contradicting what's in the zoning ordinance, I mean, we would have to appeal that, obviously.
All right. Other questions for staff? And I guess to the applicant, if at this point, if there are any. I have one question for the applicant. Oh, Mr. Malik, go ahead.
So what I would say, just for the record, let's see. So for the record, it looked like the disclosure statement had Mr. Malloy, and I don't have it right in front of me, but it just listed him individually as the owner. But it did look as though he has a disclosure statement. So in the table where it states the name of the owner, it just has him personally as owner member, but then under the address, it has the limited partnership. And so I would just, point that out, whatever clarification staff needs to do for the record on this. I mean, because all the parties are in there, but they're just kind of in the wrong place. So I just for the record thought I'd point that out. Because it's my understanding that the limited partnership's the owner.
Correct.
So the disclosure statement is a little confusing because under address, they put in the limited partnership, and in the down later, they just call out the owner as being Maxwell Malloy. So if that's of concern to the county in any way, Mr. Melnick has pointed that out to you. I have a question for the applicant. Ms. Petro, is there any law or precedent that you are directing towards us in this matter that would support your position?
I am not aware of any, because frankly, I don't know where to look for that. I've never been in this position. I've never, represented a client who's purchased a property that his use does not conform with the current zoning. Although I do know that there are certain properties in Arlington County that have been grandfathered in, meaning they're allowed to be used as they were in the past. I was under the impression that this was one of them, considering the length of time it's been operated as a 3-unit and the utility setup. However, no, I don't have any precedent to bring to the board on this particular case.
Okay, thank you. Mr. DePietro, do you understand that, I think it was you wrote the letter about the variance, that a variance would not work in this case, and certainly it's not, a variance is not before us at this time.
Yeah, I was given a little bit of direction by the inspector, and also with the help of a couple of the Arlington County zoning staff, on which way to go here. Again, I don't have a ton of experience in this, so I was just kind of following what I thought were correct orders. I'm not sure what to apply for. If it's not a variance, what would it be?
Yeah, I think that the problem, as both the zoning administrator and the attorney have pointed out, is that it's there isn't any remedy that the BZA can offer that we understand, at least at this time. We can neither grant your use or grant a variance at this time, because a variance would not solve your problem.
Understood. What would be the course of action at this point? We want to make sure that we're, following the rules here.
Sure.
I certainly don't want to be the person who's, disobeying county law and all of that. And
I can't advise you. I don't know if staff is willing to advise you at this point, or if that's something you want to do after the hearing.
Madam Chair?
Yes, Mr. Melnick?
So what I would say is a lot of the things brought up about, the listings, representations and all that. So those, there's other venues for handling that, like contract disputes between parties and that sort of thing, but it's not us. Like, we can't adjudicate this sort of thing. Like, if somebody has a contract problem, that can't, that's not a reason for us to make a decision. And I think it sounds like that's the thing, is that maybe there's another venue for this, but it's just not us in reference to the things that we're saying about the leases and any representations and just the fact that they didn't know this or that it's been used this way for so long. But, definitely, the applicant should investigate, however they can, what their rights are all around. But we're strictly dealing with, the zoning law, the zoning ordinance. So that's what I would say is we're just very limited here in what we can apply, which is a zoning ordinance.
Ms. Freshman.
Assuming that the zoning administrator's decision is upheld, which I certainly would, is the applicant then have to have one of the units vacated in order to be compliant, or else there is some action taken by further action taken by the county? Is that the process?
So generally, after a BZA decision, we wait to see if there's going to be an appeal of that decision before we initiate our kind of typical enforcement process. So there'd be a period of time to see what direction the owners go in. And then we would reach out and probably start the process. We understand the decision was made on this date. It's been a month. We need to come and talk to you or visit and inspect and see if it's been remedied, and then kind of start that process.
Okay. And in the meantime, as Mr. Melnick suggests, if there's other litigation related to the purchase or misrepresentation or whatever, that's a separate action that the owners can take. But they're still going to be facing the issue of compliance with the county.
Yes.
Thank you.
Any further discussion? Do we want to move to a motion?
Yes. I move the Board of Zoning Appeals uphold the decision of the zoning administrator in the case of V-11696-21-APP-1.
Second.
All right. Motion made by Ms. Freshman, seconded by Ms. Arthurs. Any further discussion? Just to the applicant, I think you need I would think you would want to seek counsel on what all your options are at this point, as Mr. Melnick indicated.
Sure. As it relates to, though, next steps and enforcement, to try to get some sort of exception made for the use, where do I go for that?
All right, that you need to talk to staff about, and that'll be after this meeting.
Okay.
But I think you may need your own representation so that you understand what your rights are.
Sure.
So there being no further discussion, I'll call the roll. Mr. Melnick?
Aye.
Ms. Freshman?
Aye.
Ms. Clark?
Aye.
Ms. Arthurs?
Aye.
Chair votes aye. So the motion to uphold the zoning administrator carries 5-0. Thank you, everyone, for laying it out so clearly for us.
Thank you so much.
Thank you.
Mr. Rissy? Or
Thank you.
Mr. Rissy or Mr. Bowen? We have a couple more matters we have one more matter that I know of, and that is to approve the minutes.
I'll move approval of the August 18, 2021 minutes.
A second.
All right, motion to approve the August 18 minutes made by Ms. Freshman, seconded by Ms. Arthurs. I'll call the roll. Mr. Melnick,
Aye.
Ms. Freshman,
Aye.
Ms. Clark, I think you abstained.
Abstain.
Ms. Arthurs,
Aye.
chair votes aye. Motion to adopt the minutes is 4-0 and 1 abstention. Any other business?
I just welcome Portia and congratulate her on completion of the first meeting in forever.
Well, thank you. I am,
Smiling face.
yes,
You made it all the way through.
all the
Yay.
way, but it was not a long one like I expected.
We all
Well-
made it all the way through. How about that?
Yes,
Yeah,
You
We're
were
actually done
quick
early.
meeting. Short.
I'm used to
short.
10 o'clock, 11 o'clock.
yeah, we're trying.
It's a lot better.
Yeah, staff is helping us, and we're trying to figure some things out here to get us so that we're not here all night. And then,
That's great.
yeah,
We all get a
Congrats.
little punchy after 10, so 10 seems to be our cutoff time, which is good.
yep. And congratulations, Mr. Bowen, for successfully
Yay.
concluding your
Thank you.
first meeting.
Thank you. Thanks to Mr.
And
Rich.
Mr. Rissy, we're always glad to see you. Anything else? Otherwise,
Bye-bye.
wait, I have to say, the agenda having been concluded, this meeting is adjourned.
Oh,